For the 1940 Lanham Act building wartime community facilities, see New Deal #Wartime Welfare Projects. The Lanham Act is the primary federal trademark statute of law in the United States. The Act prohibits a number of activities, including trademark infringement, trademark dilution, and false advertising. History. Named for Representative Fritz G. Lanham of Texas, the Act was passed on July 5, 1946, and signed into law by President Harry Truman, taking effect 1 year from its enactment, on July 6, 1947. In rare circumstances, a conflict will arise between trademarks that have been in use since before the Lanham Act went into effect, thus requiring the courts to examine the dispute according to the Trademark Act that existed before the Lanham Act. The Act has been amended several times since its enactment. Its impact was significantly enhanced by the Trademark Counterfeiting Act of 1984, which made the intentional use of a counterfeit trademark or the unauthorized use of a counterfeit trademark an offense under Title 18 of the United States Code, and enhanced enforcement remedies through the use of ex parte seizures and the award of treble profits or damages. In 1999, the Anti-Cyber-Squatting Consumer Protection Act inserted 15 U.S.C. Section 1125 and amended 15 U.S.C. Section 1114. Civil enforcement sections 42 and 43 of the Act set out the remedies that can be sought when a trademark is infringed. These provisions forbid the importation of goods that infringe registered trademarks, and restrict, through the use of injunctions and damages, the use of false descriptions and trademark dilution. Section 43 is the likelihood of confusion standard for infringement of an unregistered trademark or trade dress, and courts still frequently refer to the provision as Section 43. 15 U.S.C. Section 1125 false designations of origin, false descriptions, and dilution. Forbidden civil action. Any person who, on or in connection with any goods or services, or any container for goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false misleading description of fact, or false misleading representation of fact, which is likely to cause confusion, or to cause mistake, or to deceive as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person, or, in commercial advertising or promotion, misrepresents the nature, characteristics, qualities, or geographic origin of his or her or another person's goods, services, or commercial activities, shall be liable in a civil action by any person who believes that he or she is or is likely to be damaged by such act. 15 U.S.C. Section 1125 is often used when false misleading statements are alleged to have hurt consumer or business. The claimant must prove that a false misleading statement was made in commerce and that the statement creates a likelihood of harm to the plaintiff. 15 U.S.C. Section 1125 is often used when false misleading statements are alleged to have hurt a business. Jurisprudence. The Act has been held to have extraterritorial impact, and the circuit courts have been giving more favorable interpretations in extending its scope. The original ruling by the Supreme Court of the United States, as interpreted by the United States Court of Appeals from the Second Circuit, contemplates a three-part test in determining whether the Act applies. The conduct of the defendant must have a substantial effect on United States commerce. The defendant must be a United States citizen and there must be an absence of conflict with foreign law. Although the Lanham Act sets out clear parameters as to what constitutes trademark infringement, subsequent court decisions, especially those involving the Internet, have loosened the strictures. In 2003, the U.S. Supreme Court ruled that the law had no impact on public domain works in Dasta Corp. v. 20th Century Fox Film Corp. In 2014, the various interpretations that had been adopted by the circuit courts as to who had standing to sue under 15 U.S.C. Section 1125 were ousted by the court in Lexmark International v. Static Control Components, where Justice Scalia adopted a multi-step approach. Under Article 3, the plaintiff must have suffered or be imminently threatened with a concrete and particularized injury in fact that is fairly traceable to the challenged action of the defendant and likely to be redressed by a favorable judicial decision. AGC requires the ascertainment, as a matter of statutory interpretation, of the scope of the private remedy created by Congress, and the class of persons who maintain a private damages action under a legislatively conferred cause of action. A statutory cause of action extends only to plaintiffs whose interests fall within the zone of interests protected by the law invoked, and the zone of interests formulation applies to all statutorily created causes of action, as it is a requirement of general application, and Congress is presumed to legislate against the background of it, which applies unless it is expressly negated. A statutory cause of action is also presumed to be limited to plaintiffs whose injuries are proximately caused by violations of the statute. A plaintiff suing under Section 1125 ordinarily must show that its economic or reputational injury flows directly from the deception wrought by the defendant's advertising, and that occurs when deception of consumers causes them to withhold trade from the plaintiff. Direct application of the zone of interests test and the proximate cause requirements applies the relevant limits on who may sue under Section 1125. In 2014, the U.S. Supreme Court ruled in POM Wonderful LLC v. Coca-Cola Co. that the Act complemented the Food, Drug, and Cosmetic Act, allowing a company to sue for infringement by way of civil action. Divisions. In the United States Code, the Act has been divided into 4 subchapters. The Trademark Registers. Subchapter I sets forth the requirements that a mark must meet to receive a registration on the principal register, which bestows various rights on the trademark owner to prevent others from infringing the mark. Among the requirements are prohibitions against the registration of marks that are confusingly similar to existing marks, a generic or merely descriptive, a scandalous or immoral, or fall onto certain other prohibited categories. Subchapter I also sets forth certain procedural requirements, such as the submission of an affidavit of continued use after 5 years of registration. Subchapter II sets forth the form of registration on the supplemental register for certain marks that are unregistrable under Subchapter I, but may become registrable in the future, such as those that are merely descriptive. This form of registration, while not granting all the protections of registration on the principal register, does provide notice to potential infringers that the mark is in use, and also provides some procedural benefits.